Hi, I'm Meredith Cross, an attorney and partner with the divorce firm of Gailor, Hunt, Jenkins, Davis, Taylor, and Gibbs. I'd like to give you some tips on what you need to do if you've just been served with divorce papers. Let's say the sheriff has just served you with legal documents. Here are 4 steps you should take right away. The first thing you should do is review all the paperwork you've received. In reading the paperwork, you need to determine what relief the plaintiff is seeking. The plaintiff is the person who initiated the lawsuit against you, usually your spouse. For example, the plaintiff may be seeking custody, child support, post-separation support, alimony, or equitable distribution, which is a division of property. And if a case involves domestic violence, the court may have already had an initial hearing without your participation and issued a temporary domestic violence protective order to which you will need to respond. The second step you should take is determine upcoming deadlines. Read carefully through all the paperwork to see if you are required to respond or appear before the court at a specific date and time. You need to know what upcoming deadlines are looming. Specifically, look for documents titled Notice of Hearing. So, for example, when served with a complaint, you will normally have 30 days from the date of service to respond. However, let's take a case where the court has already issued a temporary domestic violence protective order. Then a return hearing will have already been scheduled within 10 days of that initial hearing, the one you weren't a part of, and you would need to return and appear and respond at the return hearing. So pay careful attention to these deadlines as they're very important for your case. The third step is to gather information. In response to legal paperwork you received, you will need to begin gathering information and documentation in support of your case. Depending on the type of case, this may require you to seek up to a year's worth or more of bank statements and other financial documents. If you've received a subpoena or discovery request, you may be required to produce information at a specific date and time or within a specified time frame. Here's an example. Suppose you want to be sure to get a fair amount of alimony. You would need to gather a year's worth of credit card statements, bank statements, retirement statements, investment accounts, and other documents to show proof of your financial needs and standard of living during the marriage. The fourth step and final one is to hire legal counsel. Depending on whether temporary hearings have been scheduled in your case or if you have fast approaching deadlines, your decision to hire an attorney may need to be made quickly. I recommend hiring an attorney experienced in family law and someone with whom you feel comfortable working. Once you hire your attorney, he or she has the ability to ask the court that your court date be moved so that you have ample time to adequately prepare. I hope this helps. Please feel free to contact me at the contact information in this video. And please comment and share.